Hello again, a very warm welcome to today's webinar, which is the first in a series of 3 webinars, which are focusing on managing your subsidiary companies, maximising their potential, and also looking at ways to exit and terminate your subsidiary arrangements. I'm Poppy Short. I'm a partner in Mills and Reeve corporate education team, and I will be chairing today's session. Helen Hirst, who is also on the screen, is a senior lawyer in the team, and she's going to be delivering the training, and we should have time for questions at the end. Both Helen and I frequently advise universities and charity clients on issues relating to managing your trading subsidiary. So we've drawn together some of the key themes and common issues that we often see and questions that we often get. And hopefully today will be a really useful session. Just very quickly, we've got some brief housekeeping. If you've got any questions, please put them in the Q&A box and we'll try and get to them. If we don't get to all the questions today, we will follow up with an email where we can and give you a response. Secondly, there will be a recording of today's session, which will be circulated afterwards, should that be useful. And finally, there will be an opportunity to give your feedback. So we'd be really grateful if you could do that at the end. A link will be sent to you. In terms of the agenda for this short session, it is 30 minutes only. So we will be looking at things in quite a high level, but we're going to be looking at when you have to or you might want to set up a subsidiary company, what type of subsidiary company would be best for using in each scenario, what kind of parental company controls or parental university controls does the university want, ways to manage the ongoing relationship and some good practice to make sure that you've got in place, and also what does good governance look like. So without further ado, I hand over to Helen. Thanks, Helen.
Thank you, Poppy, and good morning, everybody. So when to set up a trading subsidiary, a university may decide to set up a subsidiary for a number of reasons. These may include reasons such as ring-fencing risk, wanting to undertake activity outside the university's charitable objects, or transferring staff. A subsidiary can include a trading subsidiary or an exempt-linked charity. A trading subsidiary is what you would consider to be the usual subsidiary company, set up to trade and generate profits to give day back to the university. An exempt-linked charity is a subsidiary where the activities also further the university's charitable purposes, but for some reason the university wants to keep those activities separated from the university. And we'll refer to those 2 terms, the trading subsidiary and the exempt-linked charity, throughout the webinar today. So when considering the proposed activity and whether or not to set up a subsidiary, the starting point is to look at the university's charitable objects and power, to consider, number 1, whether the proposed activity is furthering the university's charitable purposes. Then the activity can either be undertaken within the university or within an exempt-linked charity. If the university is a higher education corporation, then the objects and powers are the same as for other HE corporations as set out in legislation. Other universities will need to consider their role charters or other governing documents. However, the objects for most universities will likely to include events in education or similar wording. Some universities will have slightly narrower objects, and others may have a specific beneficiary class. If the proposed activity is outside of the charity's purposes, or there is some other reason to ring-fence risk of the activity into a subsidiary, then the next step is to consider whether it is in the university's powers to set up a subsidiary vehicle, whether that is a trading subsidiary or an exempt-linked charity. This is unlikely to be an issue for HE corporations if the powers are enshrined in legislation, and equally for universities with royal charters, as they tend to have a wider power as they have the rights and powers of a natural person. At this point, it's worth considering a couple of examples to show the thought process for deciding whether a subsidiary is required and to demonstrate that it's not always clear-cut because there may be mixed motives for undertaking an activity. The university wants to establish an education centre to provide outreach education for the local community. This type of activity is most likely to be within the university's charitable objects. Therefore, the activity could be undertaken within the university, or an exempt linked charity could be set up in order to ring-fence some of the risk. The university wants to establish a research centre. Now, it depends on what the arrangements are for that research centre. If, for example, that research is to further the university's objects and it is for public benefit, then that research could be undertaken within the university or potentially within an exempt linked charity. However, if the research is for commercial gain and or with a commercial joint venture partner, then it is more likely to need to be undertaken within a trading subsidiary. After you've considered the objects and powers, you need to consider any policies and procedures that the university may have regarding setting up a subsidiary. These may include details about how you will decide when to use a subsidiary and who will approve that decision. It may also require that a business case is submitted as part of that process. And it could be helpful as a university to prepare a decision tree to help make that process clearer. So what are the risks of running the commercial activity through the university? I think it's worth explaining that the basic principle is that non-primary purpose trading is undertaken within the university must be ancillary to furthering the charity's purposes. And it will be subject to corporation tax unless that activity is within the small trading exemption limit. That limit is £80,000 total of non-primary purpose trading, where the income of the charity is over £320,000 per annum. Universities will usually decide to set up a trading subsidiary to undertake non-primary purpose trading, as the income will normally exceed or cumulatively will exceed the small trading exemption limit. As those non-primary purpose activities will be subject to corporation tax, undertaking those activities in a trading subsidiary means that the trading subsidiary can then gift aid its profits to the university, thereby offsetting the corporation tax liability. The risk of not doing this properly is ultimately you paying corporation tax and non-primary purpose trading is a breach of tax law and potentially a breach of trustee duties by the university's council. And finally, just to mention on this slide that you also need to consider whether the subsidiary should be wholly owned by the university or whether it should be a subsidiary of an existing subsidiary. Those types of considerations will be largely driven by tax considerations, but we're not considering that any further for today. So just briefly, as an example, the university might establish a sports centre within an exempt linked charity initially, as it's mainly used by university students. However, if the sports centre is also open to members of the public and that use by the public becomes more significant, then it might be necessary to put that activity into a separate subsidiary or a sub-subsidiary of the exempt linked charity. So now I need to consider how to structure the subsidiary. I'm only briefly going to mention these different types of vehicles for completeness, but the most common forms that you will see for a trading subsidiary are a company limited by shares, and for a linked exempt charity, a company limited by guarantee. So a company limited by shares has a share capital which provides a mechanism for paying dividends to the shareholder. The legal liability of the sole shareholder will be limited to the payment of share capital held by it in the subsidiary. A community interest company could also be used for a trading subsidiary. These can be limited by shares or guarantee. They're not a charity, but it does include a community interest statement and an asset block, so certain community features. For a linked exempt charity, most commonly you're going to see a company limited by guarantee. This has no share capital and has members rather than shareholders, and the member is only liable to contribute the amount specified, so for example £1 or £10 on winding up the company. And finally, to mention the charitable incorporated organisation, so CIOs are just registered with the Charity Commission and not with Companies House. However, although it is a valid option, it would be preferable for university to choose the company limited by guarantee option for a linked exempt charity. And that's because CIOs are not exempt charities, and therefore you'd have to go through a process of registering with the Charity Commission. So one of the important considerations for the university is thinking about what level of control it wants to have. The university has a distinct role as a shareholder or member of the subsidiary. The governing document of the subsidiary, so usually the Articles of Association, will set out the decisions to be made by the shareholder. The Companies Act 2006 also specifies certain decisions that are required to be made by the shareholder. Therefore, the university should consider what processes it has in place for making those decisions and who makes those decisions. You may find it helpful to have a scheme of delegation or a framework put in place that sets out who makes those decisions. We recommend that you undertake a review of the Articles of Association for each of the university's existing subsidiaries in order that you fully understand their requirements and also to check whether they are up to date. Some subsidiary companies may simply have adopted model articles upon incorporation. Model articles are the standard default articles for companies to use. However, they are unlikely to fully meet the needs of a university group structure. We recommend adopting bespoke Articles of Association for each of the subsidiaries, and ideally adopting the same articles for each subsidiary across the whole group. This will make it easier for the university to manage its role as shareholder. If you were to adopt bespoke Articles of Association, then they can include protections for the university as shareholder. So these provisions could be things such as matters reserved for the shareholder. However, please note there is a potential risk of the shareholder, if it were to take over the director's decisions, that it could be construed as a shadow director. However, this is not likely to be relevant if we're talking about an exempt-linked charity, and there is a high tolerance for a wholly owned subsidiary. You could also include provisions about the university appointing all or some of the directors. Ideally, even if the university is appointing all directors, there will still need to be an independent director in order to follow Charity Commission guidance for connections with non-charities. And finally, you can also include what we describe as safe harbour provisions, which effectively bless the conflicts of interest for those directors that are also on the university's council or on other subsidiary boards, or if they were also an employee of the university. Please note that the use of the safe harbour provisions is not the only way to manage conflicts of interest, as I will explain later. So how should the university manage its ongoing relationship? All funding and services provided to a trading subsidiary by the university must be on an arm's length basis. This is because charitable funds must always be used to further the university's charitable purposes and be for public and not private benefit. So for a trading subsidiary, any funding provided by the university would have to be justified as a qualifying charitable investment. This means that a reasonable return, comparable with other investments which could be made, would have to be included to avoid the university risking incurring taxable non-qualifying expenditure. In considering the type of funding available, the university would need to consider what working capital will be required. This could be provided by the way of a loan from the university, which ideally should be secured and would charge interest. It could be a third-party loan, including joint ventures, or it could be an equity investment by the university in the share capital of the subsidiary. The key advantage of the university loan route is that it will provide the university with a more straightforward mechanism to get the money back and receipt of interest payments. Third-party loans, including joint ventures, may be more expensive and require the university to lose a degree of control and/or returns. For example, if the joint venture partner will also be a shareholder or other commercial arrangement for them to receive a return. Equity investments can be beneficial for the university as they're not on the balance sheet. However, please note that if you were to choose the equity investment route, then it is a little harder for the equity get the equity back to the university compared to if a loan was used. However, technically it is possible by way of a reduction of share capital. In terms of services, we'd recommend putting in place an intergroup services agreement, which sets out the services that the university will provide to the trading subsidiary and the charges that the trading subsidiary will pay for those services. It can be helpful to prepare one template that can be used across the whole group, with schedules that can be amended to reflect the requirements for the services of that particular trading subsidiary. The charges made by the university should not be discounted, as they should reflect an arm's length arrangement and includes the use of university staff time. The charges are sometimes referred to as a cost plus contribution. The typical things we see included in such an agreement are back office support, including HR, finance and marketing, using the university's intellectual property, normally its name and logo, which requires a formal license to be put in place, data processing arrangements, use of the university's premises, which could be covered by licence provisions, or it may be necessary to have a separate lease depending on the circumstances. If the subsidiary or the university wants to develop the property, then this may be difficult if the subsidiary does not have a property interest. For example, a university operates a conference centre that belongs to the university without a lease in place. It would be better for the security of both parties to have a lease in place. It depends on the nature of the activities undertaken. Those activities further the university's purposes that will determine the level of rent. If the conference centre is purely commercial, then a market value rent would need to be charged. However, if the conference centre is also used for the university teaching purposes and the subsidiary is therefore an exempt-linked charity, then a peppercorn rent may be more appropriate. So it's looking at the circumstances of each arrangement. For exempt-linked charities, funding, assuming that it's furthering the charitable purposes, then the university can make a more relaxed approach to the funding the subsidiary. So it could transfer funds by way of a gift, grant or loan, and the loan would not need to be on market terms. In terms of services to exempt-linked charities, a formal agreement is less likely to be needed, as staff in the university and the subsidiary are all working to further the university's charitable purposes. However, the university may choose to have such an agreement in place. Other considerations that you might want to bear in mind, we recommend reviewing and consolidating the current university group to consider any companies that you have dormant, any that you might need to wind up or could repurpose for other projects. And is it possible to make the structure more efficient? But please note there are implications about moving the business between intergroup companies, including 2P and tax. It's important to consider who you're appointing to each subsidiary board to ensure that you have an appropriate mix of skills and independence on each board. You should consider carefully who is on each subsidiary board from a conflicts perspective. For example, the financial director of the university making decisions which may have an impact on the subsidiary may not be the best person to have on the board of the subsidiary. It is also helpful to review the effectiveness of the board from time to time and provide training where required. We recommend reviewing the subsidiaries on an annual basis, following a framework or policy for the universities or subsidiaries, and reviewing the services agreements and other agreements in place between the university and its subsidiaries so that they continue to reflect a fair and accurate proportion of the university staff time and resources being used to support the subsidiary, ensuring that those are reviewed at subsidiary and university level. And finally, who monitors the subsidiaries within the university? What reporting is made about the activity of the subsidiaries, and who are those reports made to? The university should aim to set this out within a framework or policy so that it is clear. And what does good governance look like? I just wanted to touch on a few points here. So making sure that there's a separate board meeting held for each subsidiary, and you should check the company's articles of association for details on how the board is to take decisions. There's a duty to take board minutes of all proceedings at meetings of directors. If this is not done, every office in default has committed an offence. Minutes are evidence that all decisions have been made correctly at the time. Managing conflicts of interest. I mentioned earlier about using safe harbour provisions, but there are other ways to manage conflicts of interest. You should make sure you maintain a register of interests, but also ensure that if a conflict arises where you cannot rely on the safe harbour provisions, then that conflicted person does leave the board meeting and does not vote, and the minutes should reflect that this has happened. It's worth considering having different people on different subsidiary boards where possible in order to ease the conflicts of interest within the university group. You need to make sure that statutory records and accounting records are maintained in order to comply with the requirements of the Companies Act. The statutory records include details such as the register of members, and this must be written upon incorporation and updated to reflect any changes. Statutory registers need to be kept up to date, because if you ever want to sell the subsidiary, change membership or transfer, then you need to make sure you have a clear membership history. As a director for the company, you have a personal responsibility to ensure that the accounting records are maintained so that they are at any time able to demonstrate and explain the financial position of the company. And then in terms of regulatory requirements, each subsidiary needs to have its own registrations, for example, registering with the Information Commissioners. It cannot rely on the university's registrations. Finally, just a few points as a checklist for you to take away. We would recommend reviewing your group structure, reviewing the Articles of Association and intra-group agreements, agreeing university policies and processes if you don't have those in place already, to ensure that there's a clear process for the university making decisions as shareholder, and ensuring subsidiaries are compliant with any regulatory and statutory records. Thank you very much. And I'll hand back to Poppy now, who's going to have a look to see if we've got any questions.
Thank you, Helen. That was really, really interesting and extremely clear. We have got some questions, so I will talk through those questions, and between Helen and I, we will attempt to answer them. So the first question is, says, we've historically appointed an independent member to our subsidiary boards, but our auditors have advised this isn't necessary. Do you have a view? Well, I'll start with this one, Helen, and you can add anything if you've got anything further to say. But certainly it is the Charity Commission guidance that commercial subsidiaries, non-charity companies of a charity, should have an independent member on them. So we would accord with that. We would align with that. I think realistically, if as long as you have got the right people on your board that aren't making decisions within the university for issues that directly impact that subsidiary company, you potentially, don't necessarily need to have an independent member. But do bear in mind, if you're following your conflicts of interest policies sufficiently and correctly, you could end up with an incorrect position where you can't get a quorum because every director on the subsidiary company is conflicted out. So in that instance, it would always be better to have an independent board member as well. Helen, do you have anything further to add than that?
Nothing to add, Poppy. I think that summed it up nicely. I think I agree with you. Ideally, it would be good to have an independent.
Okay, there's another really interesting question here. I'll read it out. Is there a risk in trading high-risk activities through a trading subsidiary where the trading subsidiary has no staff and follows the main university processes and is staffed by university staff? Would the court breach the corporate veil here and liability not be limited? I think Helen briefly touched on this earlier. I'm assuming here that the high risk activities are actually in furtherance of the university's charitable objects, but you've just decided to put them through a subsidiary company. I mean, in that instance, ideally, even though it is a sort of primary purpose activity, the university would not just put the staff in without any sort of secondment or services arrangements in place. That would certainly help to show the processes. the distinction between sort of the university and the subsidiary itself. And I, ultimately, no, the university would it would still, the activities within the subsidiary would be ring fenced from a legal perspective, albeit that the university might be ultimately responsible for the staff. You have to think in these sort of situations as well, would the university stand behind the subsidiary company in any event? And so you sort of have to think through that as well. But ultimately, you can make it work using university staff pretty well. Helen, do you have anything further to add on that one?
No, I think that's right. I don't have anything to add on that one.
Okay. Question there. When university staff or council members are directors on the company board, should there be a primary allegiance to the university or to the company? Really good question. So the allegiance should be equal. I always see this as wearing separate hats. So when you're acting in your role as council member for the university, or as an officer or staff member of the university, you are contracted or have responsibilities to the university, and you must wear that hat very firmly in that role. If you're also on the board of one of the subsidiary companies, then you have to sort of put aside that hat and think about what your roles and responsibilities are as a director on the board. And of course, companies, the roles and responsibilities of directors of companies are enshrined in company law, where they are also charitable exempt link companies. You've also got charity trustee duties to consider as well. So I think that's the short answer to that. A whole separate session on this could be had. But yes, there are two distinct roles with distinct contractual and statutory responsibilities, and they need to be seen as that.
Yeah, and I think just to add to that, Poppy, I think it's worth thinking about sometimes the directors that were appointed when the company was incorporated might not be those that are suitable once the company's developed a bit. For example, often might be incorporated using financial director just because it's somebody that's available to sign the relevant documents, but that doesn't mean it's the easiest thing for them to continue managing, wearing those two different hats moving forward. So it's probably another point to revisit, looking at who its current directors are. Absolutely.
Thank you, Helen. Can you give some examples of safe harbour provisions re conflicts? So the sort of classic safe harbour provision in Articles of Association is to bless a situational conflict by virtue of the fact that somebody on the board is also either a trustee or a council member or court member, and on that board, or an officer. So you don't then have to go through the if you have that within the articles, you don't then have to go through the consent process where the board consents without that director taking part in the quorum for that vote to clear that conflict. So that's a really useful provision to have in the articles. Sometimes there's other safe harbour provisions around not breaching confidentiality in certain situations where there otherwise might be a conflict of confidentiality between being an officer or employee of the university and also on the board. And you can have other provisions around appointment of directors and university control over those. Helen, do you want to talk a little bit about some of the shareholder parental sort of controls that the university might wish to have? You can embed these within the articles or outside of the articles, actually.
Yeah, so the university's shareholder could or sole shareholder could have provisions, so it has a power to veto any decisions of the director. Or it could be written in a more narrow way, so there's just certain decisions that would go back to the shareholder. Yeah, so there's plenty you can do, and you can make it as bespoke as you like, but I think it probably goes back to that point about making the articles of association usable across the group. So where possible, adopting a template, because if you make them too bespoke for different companies, it can be difficult to manage and difficult to remember what provisions you've got.
Absolutely. Okay, thank you so much for taking part today. That brings us, I think we're 1 minute over, so I'll draw today's session to a close. If we haven't got to your question, we will try and follow up with an email. This is on the slide here is just a reminder of the upcoming webinars, Managing Your IP Strategy, on the 24th of October at 10 o'clock, and then looking at ways to sort of exit and close down or sell your trading subsidiary, a trading subsidiary within your group, is on the 6th of November at 10 o'clock. Both of them again for half an hour. We really hope that you can join. And in the meantime, do fill in our feedback form if you've got any time. And thank you once again for joining. We hope you found it useful. And here are our details in case you have any follow-up questions. Thank you very much.